All right, everybody reloaded on their coffee, ready to go.
He doesn't.
Had some energy rings. Okay, we'll deal with, we had a little question right before we left, and I figured, well, let's take a break before we come back. So let's talk about the Shatzer case, which is a U.S. Supreme Court case that you guys went over yesterday, but is really somewhat confusing. And it's where the Supreme Court came up with the 14-day rule. Let me ask you a question. Why did they come up with 14 days?
I was told that it was just a random number. This was a previous class. It was just a random number that they came up with that said that that's enough time.
Absolutely, you're totally right. It was a completely arbitrary number. The Supreme Court said they didn't feel like 7 days was enough. They felt like 28 days or a month was too long, so they came up with the number of 14 days. They just felt like they had to give law enforcement some type of guidance when it came to talking to somebody again. Now let me tell you my experience before they were Shatzer. We had a cold case, and I was a cold case coordinator, and we had a guy who was a suspect in the crime from, this is going back to the late 80s. And we're talking about early 2000s when we rearrested him. Luckily, the guy, the sergeant who was now in charge of major case, was one of the people who worked the case initially. He had never been charged, but early on, he invoked his right to counsel. Right? And that sergeant knew that. Well, back then, if you invoked your right to counsel, you were shut down like forever. So the Supreme Court says that's absurd. Okay? Not to mention, how could one detective from 10 years ago know what somebody did 10 years from now? Right? Just so happens the sergeant was the same person who investigated the case. So what Shatzer does is says that if you invoke your right to counsel, remember, Fifth Amendment, you invoke, say, I want a lawyer. Right? You have to have a 14-day break before you can go talk to him again. Okay? So that's what Shatzer says. It's only for the Fifth Amendment. So don't get confused. If Mr. Miranda here was arrested for grand theft auto, went to first appearance, and got assigned an attorney for first appearance, that's his Sixth Amendment right. The 14-day rule does not apply to that. Nobody can ever talk to him again about that grand theft auto unless he contacts us and reinitiates. We cannot reinitiate. That's a Sixth Amendment right. That's been attached to that specific case. Shatzer and the 14-day rule only apply to Fifth Amendment, I asked for a lawyer. Okay, so think about that. So if you work a burglary, guy says, I want a lawyer, you get some more information. 3 weeks from now, you can go back and ask him more questions. You'd have to reread him his rights. He'd have to invoke again, or he may not invoke, he may waive his rights, and then you can ask him questions.
So if you go do an interview on the guy in the jail after he got arrested and you got an attorney assigned to him, is that what you're saying?
So he's got, it's for that case only, right?
I put a warrant out for grand theft auto, and he gets picked up in Lake County. I work Marion County. I drive to Lake County and go front for him. He's already been the first appearance.
It depends. Now, you're getting, all right, so we're kind of tangenting off Shatzer, which is okay. It really depends, because if you have an out-of-county warrant and they go to first appearance, the judge may say, I'm not giving you a public defender. I'm going to wait till you get back to Marion County before you get your public defender. So those are very specific cases where you're going to have to work with your state attorney to figure out whether or not the guy got assigned one. There are some counties, regardless of what the case is, they're going to assign him a public defender for that case, even though it has nothing to do with their county, right? But that's what they do. That's what the judges do there. But a lot of counties are like, nah, you're not getting a public defender. When you get back to Marion County, you'll go to first appearance there, they'll give you a public defender in Marion County. So a lot of times you still have a chance to go talk to them. The key is really what? Always get to them before they go to first appearance as best you can, right? Then you're always safe. You're always safe.